Bismillahirrahmanirrahim. Subject name is Interpretation of Statute and class is 5 year 10 morning. My dear students, lecture number 1 is when a question comes before the courts of law, when a question of law comes before the courts of law, what are the modes of interpretation of that particular question? Dear students, as we all know that there are three organs of the state. First is the legislature, second is the executive, and third is the judiciary. The function of law making is the first and foremost task of the legislature, which is the parliament at the federal level and provincial assembly at the provincial level. So that law which has been made by the parliament or provincial assembly, as the case may be, must be executed or imposed by the executive. And in the process of its execution, if there are certain complications, certain complexities involved regarding its execution, then this law can be brought before the judiciary in order to interpret it whether it is a viable law or not. So here comes the functions of the judiciary, interpretation, which is our subject as well. So when a question of law comes before the courts of law, the courts are supposed to interpret it. Now the first thing is this: what is the question of law? It is quite simple. A question which is answered by the law itself is a question of law. Meaning thereby, if I ask, uh, what is the punishment of theft? Or what is the punishment of Katle Ahmad? Or what is the punishment of hijacking? Then you can answer this question by looking into the book of the law, which is Pakistan Penal Code, and tell me its punishment. So a question of law is a question which is answered by the law. In its comparison, there is another question, which is a question of fact. A question of fact is a question which is not a question of law, but which is a question over which evidence has to come. And this is a question of fact. So, a fact is basically something which has happened or something which has been occurred. So, one party is supposed to prove that this incident has not happened, and other party has to prove that this incident has happened, or one party has to prove that my client has not been involved in the occurrence of this particular incidents or incident, and the other party is, incriminate, other party will incriminate that particular person that he was involved in the commission of this particular act. So there are two questions which are very pivotal and comes before the courts of law. So as far as the question of law is concerned, the apex courts, primarily high courts and Supreme Court, deal with this kind of question. Now the courts have two modes of interpretation of statute. And by the way, the statute is basically a written law made by the parliament. Any law which comprises of sections, articles, जिनको हम उर्दू में दफ़ात कहते हैं, शिक्के कहते हैं, वो स्टैचूट होता है। ख्वाह वो सूबाई असम्बली ने बनाया हो या वो वफाकी पार्लियामेंट, जिसको हम पार्लियामेंट कहते हैं, नेशनल असेंबली, सेनेट एंड प्रेसिडेंट, ये तीनों मिलकर पार्लियामेंट बनाते हैं। और अगर कोई लॉ पार्लियामेंट बनाती है तो उसको हम स्टैचूट कहते हैं या स्टैचूटरी लॉ कहते हैं। उर्दू में हम इसको कहते हैं मौजूआ कानून। और इंटरप्रिटेशन हमेशा स्टैचूट की होती है। सो बिफोर गोइंग इनटू डिटेल that what are the modes of interpretation of statute, let me clarify to you people that what is interpretation per se. My dear colleagues or my dear students, interpretation is basically the dissection of the law, clause by clause, provision by provision, punctuation by punctuation, and try to find out the overt as well as the covert meaning of the statute. Or let me put it in a very simple way, the object of the interpretation is this: to find out the true intention behind the legislation of that particular law by the legislature. So if we want to look at the very letters of law, we have to understand that under what circumstances Parliament has made this law, what was the intention of the Parliament behind it, and what is the usufruct of this law for the public at large. So this is what interpretation is. Literally, I can say that interpretation means explanation, comprehension, elaboration, or you can say uh, a kind of simplification of the wording of law by the competent or learned uh, judges of the Supreme Court or High Court. Since they have spent decades in the field of law, so they are in a better position to understand the letters of law by by reading it again and again. So the beauty of the law is this: you read more, more, you find out different meanings. Every reading will give you a different meaning of it. So this is the beauty of the wording of the text of the statute. So this is what interpretation is. And statute, as I told you, as I already told you, that statute is basically a written law made by the parliament. Now, whenever a statute statutory provision come before the courts of law, they have, mainly speaking, generally speaking, they have two modes of interpretation of the statute. Number one, literal rule of interpretation, जिसको लैटिन में हम लिटरा लेजिस भी कहते हैं, लिटरा लेजिस. एंड द सेकंड रूल ऑफ इंटरप्रिटेशन इज लॉजिकल रूल ऑफ इंटरप्रिटेशन, जिसको हम लैटिन में सेंटेंशिया सेंटेंशिया लेजिस कहते हैं. So these are the two modes of interpretation of statute which courts will exercise, keeping in view the case. So it means they are not supposed to apply both the modes of interpretation of statute simultaneously. No, they may apply either literal rule of interpretation or logical rule of interpretation. So the literal rule of interpretation. The courts of law will read clause by clause the statute, and if they see that the wording or the letters of the law are meaningful, expressive, give categorical meaning, there is no ambiguity, there is no involvement of any kind of uncertainty, they will apply that law as it is. They will not depart from the wording of the text, provided that if the wording of the text is clear, unambiguous, obvious, and comprehensible, then they would follow it. For example, if they say that a child under 7 years of age is having no mens rea, he is innocent. So let me quote the exact section of the statute. Section 82 of the Pakistan Penal Code says, and I quote, that a child under 7 years of age is immune from mens rea. He is exonerated from mens rea because he is not a mature person to perceive the consequences of his act. So, if any act done by him will be presumed that it was done in exclusion of mens rea or actus rea. Actus rea is very much there, but mens rea is not there at all. So, if you look at this section, there is no ambiguity. It's a categorical section. It says that whosoever commits a crime, if he's having age less than 7, then he's innocent. So, in that particular case, the court will not depart from the letters of uh, the statute. Court will apply it as it is. Now, there is another scenario which we will discuss in the logical rule of interpretation. So, as far as the first rule of interpretation is concerned, we are, I'm very hopeful that at the same page, that literal rule of interpretation is applicable when the wording and the text of law uh, does not give more than one meaning, does not give liberty to its reader to go beyond its text, keeping in view any absurdity in the text of the statute, and the courts will, implement it, apply it on that case which is, under their hand as it is, and dispose it of. So there is another rule of interpretation which is logical rule of interpretation. As you can see, that logical rule of interpretation, uh, you know uh, is demanding a little more detail. When the wording of the statute bears more than one meaning, or when the wording of the statute is is ambiguous, is you know dubious, or something is left up to the wit and wisdom of the judge, and there is a cushion, and there is a plenty of room for the judge to apply his own mind on that particular case, then the judges will depart from the wording of the statute and go beyond its textual content and keep in view the logic, rationale, or reasoning of that particular law and then apply it. For example, under section 379 there is a punishment of theft, that whosoever will commit a theft, he shall be punishment for imprisonment of 3 years or fine or both. Now, in this particular section, it is not mentioned that a person who commits a theft shall be punishment with imprisonment of 3 years at all, exclusively. So if that was the case, then the judges will not go beyond the text of the statute, because it is quite clear that the punishment of theft is 3 years. That's it. Now, in this case, the punishment of theft is threesome. It may be 3 years of imprisonment, or it may be fine, or it may be both. Or there is another scenario. The judge is not supposed to give. Suppose if judge says that I will give him imprisonment. So if the judge will see that he is not the person who is involved, who is allegedly involved in a case, is he is he is not a hardened criminal. He's not a habitual criminal. He's just a student, and he stole a piece of bread from a bakery just to, uh, you know, he was starving and he wants to save his life. For that particular case, he has stolen a piece of bread, and this is a theft. But on the other hand, a person who has stolen a huge amount of money from a bank, both are thieves. But should their punishment be the same? Hmm? Should both of them be punished for 3 years? No. It is up to the judge. He will look into the case. He will see that a person who has committed an offense, what was his previous record? What was the magnitude of the offense? So, on the one hand, there is a piece of bread which has been stolen, and on the other hand, there is a huge amount of massive amount of money which has been stolen. So this is, this will be called the magnitude, the intensity, the quantum of the offense. So whenever the judge will award punishment to the criminal or to the accused, he must keep in view three things. So these are, you can say it may be another question, that what are the measures of determination of the criminal liability. So this is another question, and we will cover both questions at the same time. So what are the measures of the determination of the criminal liability? Whenever there is a whenever there is a commission of the crime, the judge will see before giving punishment. So it is proved that crime has been committed, this person has committed a crime. So the judge, before awarding him the punishment, will keep in view three things in his mind. Number one, what was his previous record? Was he hardened criminal, or is he hardened or a habitual criminal, or he has just committed a crime by chance, for the first time? He has no previous record, he has no previous criminal record. One ground. Second, what was the magnitude of the offense? Is there a theft of millions and millions of rupee, or is there a theft of only piece of bread? So what is the magnitude? On the one hand, there is a very light magnitude, slight magnitude, and on the other hand, there is enormous magnitude. So in both cases, the punishment will be the same or lighter. So definitely punishment will be the lighter. So third, motive. What was the motive behind it? Motive was to satiate his hunger, or motive was to fill his bag full of money and go and make it a habit, or just to create a mockery of the system and do it again and again for the ulterior motives. So motive is the third criteria before the awarding of the punishment, and it will also determine the criminal liability. So these kind of discussion will be involved in the logical rule of interpretation, when the judge will apply this case by considering all these elements, and then he may award him the punishment, he may award him fine, or he may award him both at the same time. So if a piece of bread has been stolen, what the judge should do, tell me? Hmm? Should he award him a symbolic fine, or should he send him to the jail so that he can become another hardened criminal by having the company of very seasoned criminals? Or what do you think? What should be done? Hmm. So he must be given another opportunity. He must be awarded a symbolic punishment so that he may change his life and adopt uh, lawful means to earn his livelihood, right? So on the other hand, if millions and millions of rupees have been stolen, then he must be given 3 years of imprisonment as well as fine at the same time. So my dear students, Interpretation, this is what the interpretation of statute is. So our topic of was what are the modes of interpretation of statute. So in our first lecture, after the midterm, because your final term is in the offing, which means quite near. So the question which you will, if it comes in the exam, that what are the when a question of law comes before the court, what options court have to interpret it, and what is the modus operandi of the interpretation of statute. Thank you very much. Good luck. Inshallah, shortly I will give you the second lecture on the subject of interpretation of statute. Thank you.